Hello, I'm Sarah Abdulmatolib, and I'm the symposium editor of the Texas A&M Law Review. I'm joined today by fellow Law Review staffer Mark Gannon, Professor Riley, the associate director of the Aggie Dispute Resolution Program, and we're also honored to be joined by Professor Carrie Menkel-Meadow, who is the distinguished and Chancellor's Professor of Law at UC Irvine and is one of the preeminent scholars and founders of the dispute resolution field. On March 4th, 2022, the Law Review and the ADR program will be co-hosting a symposium entitled The Renaissance Woman of Dispute Resolution, Carrie Menkel-Meadow's Contributions to New Directions in Feminism, Ethics, and ADR. We're excited to be able to have this conversation today with Professor Menkel-Meadow herself as a bit of a preview to what we are sure will be an amazing event this spring. So thank you so much, Professor Menkel-Meadow, for being here, and for all of you that have, for all that you have contributed to this field, feminism, legal ethics, legal education, and just the legal field overall. My first question for you is related to your chapter in the book, Evolution of a Field, your article titled, or your chapter titled, When Should I Be in the Middle? I've looked at life from both sides now. So you wrote, and this is a quote, "The challenges of the current polarization of our polity have caused me to question that if we simply dialogue long enough, we will all be able to get along. There are lines I will not cross and compromises I will not make about some basic values. My culture or religion is feminism in the humanist sense of equality for all people. So there are limits in where I think mediation is appropriate. So one question I have for our field is, what is or is not mediatable?" So I was wondering, how would you answer that question today?
Wow, what a fabulous question. You just picked an important question because it does relate to all parts of this symposium, my feminism, my own sense of ethics, and my commitment to dispute resolution. So fabulous question. And of course, ironically, in this very moment, I have no idea if you guys have seen it, but Kevin McCarthy has called for the impeachment of President Biden because of the current failures in the withdrawal process from Afghanistan. I don't know where we'll be in March, but it's a good place for me to start because if you read that chapter in The Evolution of a Field, I started as a political person. I grew up in New York City. I had refugee parents who were very progressive. I grew up in a cosmopolitan world. I was born literally the year of the UN, and I went to school with kids whose parents worked at the UN. So I was an optimistic kid coming out of a very pessimistic World War II and refugee situation. So as you can imagine, I've been watching the refugee crisis in Afghanistan and Syria and everywhere, and looking at the failures of decisions that we have made politically. And whether President Biden should be impeached on is not mediatable for me. There are places where I would draw the line in the sand. And if you'll let me, I'm going to say something that will be a little provocative, and we'll be able to talk about it in March. You guys are too young to remember probably, but in 2000, when we had the Bush and Gore election controversy, I was actually part, I won't name them, of a very elite group in Washington. I was then teaching in Washington. Peter, when did you come? I think after that, right after that, right?
Right after that. Mm-hmm.
Yeah. So in 2000, when we had the election crisis, a number of very distinguished former senators and cabinet officers asked me to join them in a confidential meeting because they thought Bush versus Gore should be mediated. And they decided to come to, Professor Menkel-Meadow at Georgetown to ask her to help figure out how to mediate. Now, these characters, I'm not naming them, although one of them was a Georgetown alum, thought that for the good of the country, that we should sit down in a time that was polarized then, but looks like nothing compared to now. And we talked about how we could possibly work something out, which has been done in other countries. For example, currently in Israel, when the election was sort of inconclusive, two office holders are sharing, they're going to share the premiership over a period of time. So one of the proposals were, if we got together with the Republican Party and the Democratic Party, and maybe Bush and Gore, I never was involved in talking to them personally about this, that they would share a 4-year term. rather than, this is before it went to the Supreme Court, rather than having a highly conflictual dispute go to the Supreme Court and having I've talked about brittle results from courts and having a brittle result. So we had a very interesting conversation about something that looks very polarizing. And you'll all laugh, anyone who's listening to this, was the one who had to remind these people, several of whom were several former federal judges, that we had a US Constitution. And even if we came to a solution in a mediation situation, there is law. And so sometimes, and that was one case, constitutional law provides no provision for mediation. Now, if you'll indulge me another 60 seconds, in an earlier contested election, Abigail Adams had actually suggested the same thing, because the election of 1800 was similarly not conclusive in the initial voting. And she, one of my feminist heroines, Abigail Adams, said to her husband, John Adams, when they were creating the new country, remember the ladies, which they seem to have forgotten for several centuries. But again, she said, maybe you guys could sort of sit down and share power. And I've written in some footnotes of some of my articles that if someone had taken that seriously and we created a precedent in 1800 for softer, I want to say, or less brittle solutions to problems, then we might have something closer to a parliamentary system. I mean, it wasn't in the Constitution, but a culture of sharing. So that would be an advantage of mediation. But my answer to you, Sarah, partially is what's not mediatable, unfortunately, are some things that are written in law and that must be decided. And I would say Brown versus Board of Ed was another one of those things. And so in my opinion, speaking to Texans, Roe versus Wade, sometimes we need to have a clear precedential ruling, and someone needs to say, this is the ethicist in me, that's wrong, this is right, and we just can't work it out. So those are some of the limits. For me, personally, that, so I'm talking macro here, what are conditions in larger societies and in politics and where the law is, some things just can't be mediatable. And then I would say to you that me personally, I have walked away from mediating some disputes that were counter to my own personal ethics, and feminism would be one of them, in a situation where I felt the power imbalance was just too great and could not be mediated or resolved in the mediation. And there, all I can say is, I can't mediate this case. There may not be anything preventing it. There may not be a law, but you might have to go find somebody else who's willing to do it. I personally, I've been very lucky. I have a day job as a professor. So I've been able for most of my life to act on my ethical limits. And if there was something I didn't want to mediate, I could just say, not me. So you've asked there are two aspects of this question that are really important, and I hope we follow up with in March. What's not mediatable from a macro sense, in our polity? And then what are non-mediatable situations that mediators and professionals have to deal with in their everyday practice? So I hope we'll do both the macro and the micro concerns when we all get together.
Yeah, thank you so much. I think it's so interesting to hear kind of both of those perspectives, that the big picture societal issues that come up, and then the choices that individual mediators have to make and feel comfortable with their own involvement in. And so, thank you so much.